Good afternoon to you all and welcome to our second webinar in our series concerning our experience as acting as an expert witness. Apologies for the slight delay in starting with a few technical issues, but hopefully you can all see and hear us clearly today. So my name is Andrew Pilbrow. I'm acting as your chair today for this session, and I'm joined by fellow partners Richard Greeves, our managing partner, and Peter Roberts. By way of a brief introduction, there are three of us here who are at DWD undertake expert witness work in the field of valuation in respect of both residential and commercial property. We also have fellow partners in the firm who are experts in non-domestic rating and planning matters, amongst other things. And collectively, we can cover quite a wide range of potential issues. Our geographical reach is nationwide from our office here in the City of London. So Richard, Peter and I are all registered RICS valuers and also registered RICS expert witnesses, having undertaken significant training in the field of expert witness. So what are we going to cover today? Richard Greeves is going to talk about compiling the expert report, and this will be followed by Peter Roberts, who will be discussing the experts joint meeting and preparation of the joint statement for the tribunal and or court, and his experience is in doing so. So a bit of housekeeping before we begin. The webinar has been recorded for training purposes and will be available to watch at your leisure with a link on LinkedIn posted, and in case any of your colleagues who are able to attend this afternoon's session. Also, if the audience have any questions, can you please populate these into the chat function, and we'll be happy to address these at the end of the webinar. Indeed, we already have one question raised by a delegate on registration, which we'll address at this end session. So without further ado, I'm going to pass you over to my partner, Richard Greeves, who's going to talk about preparation and compilation of the expert report. Thank you. Over to you, Richard.
Hello, good afternoon to you. I'm going to talk today about drafting the expert report. This follows hot on the heels of our previous webinar where we looked at the appointment of the expert witness. We're now looking at, having been appointed, drafting an expert report. The key factor from my perspective in the report is to define the instructions given to the expert, and in that case to outline the questions which the expert is expected to examine, consider and report upon. And the defining of that question is crucial because ideally instructing solicitors on both sides of the dispute will have agreed the wording of the question that their respective experts are being asked to consider. Unfortunately, this rarely happens. I'm currently involved in litigation where it became apparent once I'd read my opponent's report that we'd been asked similar but not identical questions. I was asked to quantify the wealth generated by an individual in his property development activities, whereas my opponent had been asked to consider the value added to those same properties by the claimant, but excluding any increase in appreciation of property values over time. Given that the time period examined was in excess of 30 years, then the figure I came out with was markedly different from that of my opponent. Had we been asked the same question, I believe actually we would have been very close in terms of numerical answers. So in that instance, if the two instructing solicitors can't agree on the exact wording of the question, then it would be better to ask two questions so that both experts can answer, one in the alternative and one as per their instructing solicitor has posed. And that way the court can then be given the decision as to how they wish to proceed with hopefully close answers from the two experts than if they've been asked different questions. So questions, I think, are the key factor. Moving on to the composition of the report itself, the first point is on factual issues, and it's absolutely imperative that the expert takes detailed notes and photographs, and those photographs should be dated and arranged in a logical sequence of elemental, locational or defect order. Experts should check and recheck measurements taken on site, ideally with a colleague present, as 2 sets of eyes better than 1, and there's less likely to be omission if there is 2 individuals rather than 1 attending inspection. And any notes taken must be the most detailed and well written possible. No expert witness ever regrets spending time and trouble taking notes when they're being cross-examined many months later. It's also important that those notes are written up immediately afterwards, whilst after the inspection, whilst facts are fresh in one's mind. If possible, it's also good practice to re-inspect the property with a draft report in hand. That's not always possible, but if so, it helps to look at a property in the context of a draft report, and it may well be necessary to clarify or expand the report following a site visit, and the expert can then read the words that have been written in the context of being physically present in the property. When relying on external sources, scientific or technical tests carried out by a third party, it's essential that the methodology used in that data collection and the identity of the party that undertook the tests must be disclosed along with their relevant experience and qualifications. It goes without saying that an expert must clearly state all material facts, whether or not it is to their client's interests or not. And it's also imperative to distinguish between facts that the expert believes to be true from those that have been assumed. Moving on to evidence, it's essential that the expert refers in the report to the reference from which evidence is extracted, if that's from a published source, or verified if emanating from a non-published source. Evidence should be laid out in a logical format and ideally tabulated to make it easier for the court to follow. I recently had to consider an opponent's expert report where no evidence had been cited in the valuation of 6 residential properties. When challenged as to why there was no evidence, the opposing expert said to me he wanted to make life awkward for me. Now, this is not good practice, as the expert owes a duty of care to the court, and omitting evidence goes against that duty. Later in this webinar, we'll be looking at drafting of a joint statement, and clearly if both experts are instructed to produce a joint statement, then the absence of evidence from one expert report hinders that duty. Above all, expert evidence should be objective, impartial and uninfluenced by the pressure of litigation or by those instructing the expert. Opinions must be kept separate from facts within the composition of the report, and if there is, as there often is, a range of opinions on any given point, then the expert should summarise the range and identify the rationale as to why the opinions differ. The expert should then give reasons why, within that range, they have adopted a particular opinion that is set out in the report. And sometimes, of course, it's not possible for an expert to give an opinion without qualification. And in those cases, the qualification must be identified with a clear explanation provided. One controversial topic in terms of the composition of an expert report is a review by instructing solicitors or counsel, and it is often the case that an expert is invited to change or expand their report. This is entirely acceptable if it ensures that the report is more accurate, its consistency is improved, it's more complete, relevant or clearer in its meaning. But it's totally unacceptable if it doesn't align with the expert's own opinion. And it's also unacceptable if it makes that expert's opinion less clear and distorted. So if a report is amended, then the reasons for the amendment that have been made should be included, and once amended it should be immediately sent by the instructing solicitor for circulation amongst all parties in the dispute. Finally, just going to touch on the publishing and exchange of the expert report and the declaration statement of truth. The statement of truth requirements differ between jurisdictions and tribunals. The common theme for chartered surveyors is mandatory for them to comply with the practice statement, surveyors acting as expert witnesses, and it's also mandatory to adopt the statement of truth and declaration as set out in the Civil Procedure Rules, Practice Direction 35. I'm not going to go through those word by word, but essentially the expert must print their name clearly underneath their signature, include all professional designations along with the date of the report, and include a statement of truth which confirms there's no conflict of interest, that the fee basis is not conditional, that all facts have been considered, and that the duty to the court or tribunal has been complied with by the expert witness. That concludes my session on the composition of the expert report, and I'll hand back to Andrew.
Thank you, Richard. That's a very useful summary of our collective process on an expert report and the process that one should go through. I'm now going to pass you over to my partner Peter, who's going to talk about his experiences in convening the joint experts meeting and preparing the joint expert statement to the tribunal or court. Thank you, Peter.
Good afternoon. Good afternoon. Thank you, Richard and Andrew. Now falls to me to talk through the experts' joint meeting and joint statement. Before I set out some practical comments from experience, it might be helpful to remind ourselves of the relevant sections of the Civil Procedure Rules and the RCS Practice Statement. Richard has already mentioned Part 35 of the CPR, and this is the starting point of any expert in understanding the behaviour and standards expected of them. Practice Direction 35, paragraph 9 states the following. Unless directed by the court, discussions between experts are not mandatory. Parties must consider with their experts at an early stage whether there is likely to be any useful purpose in holding an experts discussion, and if so, when. The purposes of discussions between experts is not for the experts to settle cases, but to agree and narrow issues, and in particular to identify, firstly, the extent of the agreement between them, secondly, the points of and short reasons for any disagreement, thirdly, the action, if any, which may be taken to resolve any outstanding points of disagreement, and lastly, any further material issues not raised and the extent to which these issues are agreed. Where the experts are to meet, the parties must discuss and, if possible, agree whether an agenda is necessary, and if so, attempt to agree one that helps the experts to focus on the issues which need to be discussed. The agenda must not be in the form of leading questions or hostile in tone. Unless ordered by the court or agreed by all parties and the experts, neither the parties nor their legal representatives may attend experts' discussions. If the legal representatives do attend, they should not normally intervene in the discussion except to answer questions put to them directly by the experts or advise on the law. And the experts may, if they so wish, hold part or all of their discussions in the absence of legal representatives. A statement must be prepared by the experts. Individual copies of the statements must be signed or as soon thereafter as practicable, and in any event within 7 days of completion. Copies of the statements must be provided to the parties no later than 14 days after signing. Of course, it's more usual the court will set out an actual direction as to when the joint statement is to be concluded and submitted. Experts must give their own opinions to assist the court and do not require the authority of the parties to join a joint statement. It's one of the points I'll be coming back to you later on. If an expert significantly alters an opinion, the joint statement must include a note or an addendum by that expert explaining the change of opinion. As Richard, Andrew and I are chartered surveyors, we are also subject to the RCS standards of behaviour, which supplement the CPR. Other experts, such as planners, architects or engineers, will of course have their own industry standards and requirements to contend with. For us, the relevant bit of the practice statement is Guidance Note 15, which is entitled Narrowing Differences and Meetings Between Experts. This is a very long guidance note, hence I won't go through the full text, but would encourage listeners to look it up and read it through in its entirety. If you're a solicitor, of course, that will help you understand what your expert valuer is required to adhere to. At the end of the day, though, it is a guidance note, hence it is best practice rather than mandatory, but it is helpful that it expands upon the points raised by the CPR and provides practical advice. It explains that the purpose of the meetings between the expert witnesses is to narrow the differences by discussion and to achieve a greater understanding of the issues in dispute. The aim is to facilitate earlier settlement and reduction of costs by mandating a proactive and cooperative approach amongst opposing expert witnesses. Unless directed by the tribunal, meetings, though not mandatory, are best practice, but should only take place with the knowledge and approval of the client. Prior to the meeting, the experts must agree that it is being held on a without prejudice basis. This again is something I wish to pick up on later on. The RCS then take the following stance. It is generally best if such meetings occur before reports intended for disclosure are exchanged, as expert witnesses can be slow to alter opinions after signing a report, and expert witnesses' time can be wasted. I'll return to this point in a moment because I fundamentally disagree with the RCS on this point. Meetings offer the opportunity for the expert witnesses to exchange and discuss evidence, pool relevant technical information, identify areas of agreement and or disagreement, and explore whether those areas may be narrowed or eliminated altogether. They should approach the meeting with a willingness to listen, be cooperative in construction, and the expert witnesses should not be limited in expressing their professional opinions on the issues by those instructing them, as the worth of the meeting can be devalued. Where expert witnesses reach an agreement, that agreement does not bind the parties unless they agree to be bound by it. The tribunal may have, or court indeed, may have directed, or the parties may have voluntarily agreed that the expert witnesses are to prepare a joint statement for what is agreed and what is not agreed. This is usually the product of several meetings and discussions and will be subject to a time deadline set by the tribunal or court. The joint statement is not to be made available for use in the, is to be made available even for use in the proceedings, and is not the wrong way around, protected by privilege. Its purpose is to define and narrow the contentious issues. The tribunal or court may have also specified particular issues that the expert witnesses must address. But the tribunal is not bound by the findings of the joint statement, but it is likely to take it into account. In this way, it is not a legal document, but it is one that rehearses the agreed facts and expresses the opinions of the expert witnesses, and it is to be their own work and not drafted, amended, and or approved by the client or their lawyer, and does not require their authority to sign it. If an expert witness materially alters their opinion after signing the joint statement, then they must provide to those instructing them a note or an addendum properly and fully explaining the change of opinion. They must also, this isn't in the practice statement as an aside, they should also consider whether their expert evidence needs to be amended. So this is a theory, but what happens in reality? So moving to the next slide, first point we have is the court timetable for the meeting. It's interesting that the courts seem to prefer the preparation of the joint statement to come after the submission of evidence, whereas the upper tribunal, rather frustratingly in my view, tend to direct that the meetings and joint statements should come before the submission of evidence. I may be wrong, but I suspect that this may be because the case management hearings at the tribunals tend to be run by RCS qualified valuer members who may be following the RCS advice, whereas legal members may not even be aware of the RCS approach. The RCS assumes that experts are in a position to discuss matters in advance of drafting their reports, notwithstanding the fact that the dates for submission of joint statements can be many weeks before the date for the submission of evidence. I'm sure that I'm not alone in pointing out that I usually don't actually know what my views are on a particular matter until I've gone through the process of carrying out my inspections, compiling evidence, testing that evidence, drafting my report, and finally standing back and forming a conclusion. Therefore, I will not want to be conceding points until I have properly considered the entirety of the evidence, nor agree matters until I am satisfied that I have enough information to reach agreement, and therefore shut off the opportunity to change my mind on certain matters. The RCS suggests that the experts will have already prepared skeleton expert reports and may even have exchanged them, but in my view, two problems arise. Firstly, the client is unlikely to want to be exposed to the cost of the expert drafting expert reports before they need to. And secondly, I would not want to issue a half-baked and incomplete report and end up boxing myself into a corner. It is usually the case, as I've just said, it is only after I've drafted my report and reflected on it that I am clear as to what I think the issues are and are happy with my conclusions and prepared to defend them if necessary. These conclusions typically change as I go through the process of drafting the report, so to agree matters having only prepared a skeleton draft is impractical and ends up misleading everyone. In my experience, joint statements produced before the submission of evidence tend to be very brief, stating the experts have met but not much else, because they can't progress discussions. Whereas joint statements produced after the submission of evidence, where both experts are aware of each other's positions and mode of thinking, are far more detailed and far more useful. I'd recommend that if either or both of the experts for the respective parties are questioning the value of a pre-submission joint statement, the legal team should not just press on regardless, but have a sensible conversation. At the risk of completely misusing legal jargon, the timing of the joint statement and the meeting should turn on the nature and facts of the dispute between the parties. So moving to the next point, where do we meet, in person or virtual? I'm very rarely successful in persuading my opposite number to attend a joint meeting in person, and it is more usual to attend Teams meetings nowadays. That's assuming, of course, I can persuade my opposite number to engage at all. But as a fallback option, conversations are had by way of the telephone, the old-fashioned way. The usual approach seems to be to have an initial conversation, followed by one of the experts agreeing to draft the joint statement, and then both of us exchanging tracked amendments. I tend to find that it is I that who has to draft the initial joint statement and send it over before I can raise any enthusiasm from my opposite number. It also helps in any case to draw up a bullet point list of the items that I think need to be discussed and email that over to them, and this usually opens the door to a conversation. I personally have no particularly strong feelings about the form of the meeting, other than to make the point that virtual meetings cut the additional cost of travelling and do appear to have become the norm. However, if the experts have not previously met or are familiar with each other, a physical meeting, in my mind, is very helpful in removing barriers between the experts, and experts are more likely to open up and be candid with each other after 2 to 3 hours of skirting around their handbags, rather than sitting in front of a dodgy internet connection. It is also much easier to pick up on body language and mannerisms if the expert is sat in front of me. So who attends these meetings? I, as a general principle, do not agree to anyone attending other than my opposite number and possibly their junior assistant, as otherwise it ends off going off track and the expert, in many cases, will simply hide behind their legal team. If there are differences in the matters of legal interpretation, my preference is for the experts to discuss them and to try and agree the questions they will ask their respective solicitors to address. But legal argument should always be kept separate from valuation. In my mind, it is far better for the experts to identify the legal points and explore the valuation issues in the alternative, and then reconvene at a later date once the solicitors have had an opportunity to discuss these matters. If the solicitors are unable to agree, the valuers will at least have discussed the different views they might have, dependent on the legal direction the court or tribunal might take, and that in itself is helpful in assisting the parties to negotiate a settlement. One issue that does arise time and time again, even with valuers who have been experts for years and really should know better, is that the number of times they openly admit to me that they are waiting for client instructions or comments from their client solicitors before being able to agree or discuss matters. It is, of course, important to keep your team up to speed, but it is not appropriate for experts to be discussing the form and their ability to agree matters with their team. Next point, cooperation rather than adversarial, remembering duty to the court or tribunal. I recently had a case where my opposite number started the conversation by saying, "Come on, Peter, you know you can't win this one. Why don't you just advise your clients to withdraw?" As an aside, his client lost the case. But I've already set out my thoughts as to the timing of the meeting, but at the risk of repeating myself, I would suggest it's difficult for either expert to narrow the issues and to cooperate in agreeing the matters of agreement and disagreement, and trying to narrow those areas if they haven't been made aware of what their opposite expert has concluded and the evidence that they have in regard to. It's also difficult to have these discussions if you haven't tested your own evidence. I should point out that most valuers are, by instinct, negotiators, and whilst experienced expert witness should know better, there is a temptation for the expert to try and start negotiations. However, the CPR and the RICS guidance is crystal clear. The expert is there to agree facts and opinions, but not negotiate the case. So next slide, please. So drafting the joint statement. There's a general understanding that the claimant's expert should draft the joint statement, but in practice, it usually comes down to whoever takes the court directions most seriously. I try to have a draft statement drawn up as early as possible to put pressure on my opposite number to get on with it. But experience has told me that whatever format I use, my opposite number will almost invariably decide they want to draft it in an entirely different manner. So it is important that experts are not too precious about the format and concentrate more on the actual drafting. There tends to be two different styles of formatting. The first approach is similar to the Scott schedules beloved to building surveyors, with the columns alongside each other, setting out the issue, one expert's view, and the second expert's view. This can be helpful in quickly identifying the issues, but if one of the experts seems to be particularly verbose, what we end up with is a totally unwieldy document where there are pages and pages of text squashed into a narrow column, whilst the other two columns are completely empty. Where this situation arises, I normally suggest that instead of using this approach, the experts simply take it in turn to set out their position. So, for example, the heading would be the issue in dispute. The first expert then sets out their opinion, and then the second expert sets out their position. And in these negotiations, it's important to find areas of agreement and to try and find pragmatic compromise. It does not give the impression of trying to assist the court or tribunal if the experts are only able to agree matters of relatively little importance. And there isn't much point in holding out on a matter of principle is little or no relevance. There's a lands tribunal case a few years back concerning the value of land being granted consent for high-rise residential development. The two experts were highly respected and well known in the world of valuation, but neither of them would agree anything, such that the tribunal wrote a lengthy missive complaining about their inability to even agree the cost of a light socket. Similarly, I've had cases in the first-tier tribunal where tenants and landlords have been arguing over small amounts dating well back before the limitation period, rather than just taking a pragmatic view and freeing up the tribunal's time to focus on the big ticket items. Areas of non-agreement, cross-referencing with expert reports. As I've said before, a statement is not meant to end up comprising rebuttals. Though I understand that where a court or tribunal refused to grant permission for rebuttals, and I have had this, it may be necessary to set out one's opinion on the other expert's position a little more than might otherwise be the case. The problem, again, going back to the RICS approach, is that, of course, the joint statement can't refer to evidence that has not yet been submitted. So again, the joint statement can end up being a much more lengthy document if both experts decide they have to start setting out their cases and protecting their position. The alternative is neither expert says anything at all, which actually is the more usual outcome. Use without prejudice. I'm sure the majority of the people on this call are more familiar without prejudice than I am with the legal arguments. But I do agree with the RICS that it is good practice for the expert to set out explicitly in writing that the discussions are without prejudice, even if it is assumed and known that it is without prejudice. Over the last 2 or 3 years, my solicitors have had to make 3 different applications requesting that my opposite number remove extensive without prejudice comments from their evidence. And the other expert has simply pleaded ignorance. The trouble, of course, is that even though the court or tribunal will state that they will disregard without prejudice matters, it is human nature that having read it, it will consciously or subconsciously still impact on their opinions. As such, the only way to deal with feigned ignorance without prejudice is to create a clear paper trail, to demonstrate that any so-called misunderstanding is deliberate and without excuse. Involvement of instructing solicitors? The answer to that, as I've already set out, is absolutely not. Their solicitors are there to provide legal advice, but they are not there to provide consent to the experts to agree matters that are not of law. Final point, finalisation of the joint statement. Firstly, the joint statement should include a statement that the experts each confirm they have not been instructed to avoid reaching agreement or otherwise defer from doing so on any matter within their competence as experts. It is amazing how many experts refuse point blank to allow that statement to be in their joint statement, which begs the question as to why. The second point is that the signing of the joint statement is not the end of the matter. In an ideal scenario, both experts will have shifted position, and the completion of the joint statement should lead to one or both of the experts then considering whether they need to amend their evidence to reflect the matters now agreed. In my experience, this rarely happens, but there have been occasions when my client's legal team have written to the other side requesting that their expert even does amend or even withdraw their evidence on the basis it is clearly no longer sustainable. This usually ends up with the matter being settled by agreement rather than proceeding to a full hearing. Overall, if both parties work with the court or the tribunal and take the joint statement and the associated discussion seriously, the experts should be able to significantly narrow down the issues. The court will be able to have clarity. There is an increased possibility for settlement. However, this is only possible if the experts and their instructing solicitors take the process seriously and make a genuine attempt to engage. Unfortunately, there is still a tendency amongst experts to defend their position and to try and deliver results for their clients, such that the joint statement and the discussions can end up being nothing more than a tick box.
Back to Andrew. I'm sure
on that note, I think I'd better hand back to Andrew. I'm sure to get Richard.
Thanks, Pete. Very useful summary of the experts' joint meeting and preparing the joint statement. And I can certainly empathise with situations where you've dealt with adversarial opposing experts who've even been combative and difficult in preparing the joint statement or trying to use tactics for submitting last-minute alterations, and takes a degree of experience and tolerance and patience to deal with those. So anyway, we've had a number of questions populated in the chat function. So we move on to the Q&A session to draw this webinar to a close. The first question is coming for Richard, I think. It says, how do you balance, Richard, using plain English with the need to address technical issues in your reporting?
Thank you, Andrew. It's quite a challenge because the expert report deals with... Sorry, I was muted, not now. It's quite a challenge because the expert report deals with issues that go beyond a layman's understanding. Inevitably, there will be terms that are not readily understood and which require some form of explanation. I tend to err on the side of caution and be basic in my explanation and try and, as much as possible, to avoid jargon and to explain as clearly as possible any technical terms that it's unavoidable to use.
Super, thanks, Richard. This question, I think, is for Peter, actually, on your subject area. This came in by a delegate before and during registration, and I think they're a solicitor. So it says, how can they, as a instructing solicitor, assist you as an expert when you're having difficult discussions with the other side's expert in preemption, i.e. before the preparation of the joint statement? Is there anything that they can do to assist in that process?
I think it is very helpful when solicitors talk to each other in a non-combative way and actually have discussion before the experts meet, so that they can try and narrow down the issues that the experts are to discuss. I'm probably as guilty of this as anybody else, but there is a risk of valuers straying into areas outside their immediate areas of knowledge and expertise, and ending up in having debates that really should have been sorted out before they met by the solicitors. So I think solicitors can be the most helpful thing, I think, from solicitors is if they do talk to each other and try to narrow down the legal issues and the areas where we are discuss matters as experts, rather than just assuming that we understand and have the correct knowledge of what we're actually being asked to do. I think it goes back to Richard's point about clarifying instructions for the report, I think the same applies to discussions that follow the report.
Great. Thank you, Peter. I think the next question is ideally covered by Richard, and this is how do you deal with a situation where your instructing solicitor or legal counsel have reviewed your report, have made comments and insist on that you alter part of your report to include something they think is relevant?
Well, I refuse to
alter anything that I'm uncomfortable with, because at the end of the day, it's my extra report. I have to stand up in front of the court, put my name on the report, and that duty overrides anything. So if I'm uncomfortable with it, I won't include it.
That's great. Thank you, Richard. And one final question. This is for Peter. I think certainly I've never had experience of this, but Peter may well have had. Have you had experience, Peter, in preparing a joint statement where the other side have not cooperated at all? You've had to submit it unilaterally to the tribunal court.
I have actually. Again, this is where solicitors can assist, in that my opposite number interpreted the directions completely different to the way my solicitor interpreted them, even though it's pretty obvious what the court required. He refused point blank to engage with me, and I ended up preparing. This is a good example of where it's helpful to have a joint statement after the report, in that I was able to review his report and mine, identify those areas where I thought we were in agreement, and then identify those areas where I thought that we were in disagreement with each other. I was able to set out my position against each of those topics, and we gave in open correspondence several opportunities for my opposite number to respond. They didn't, so we submitted unilaterally. The judge of the county court case in this particular matter, the judge responded by giving my opposite number a week to A, explain himself, and B, fill in his responses to those areas I had identified. Failure to do so, he would strike out his evidence in full. Not surprisingly, my opposite number decided to cooperate, and we were able to get over that little hump.
That's great. Thanks, Peter. Very unusual situation, certainly something I've never had experience of. So that brings the webinar to a close today, and I'd like to thank our delegates for attending and participating in this. We'll shortly be announcing the details of our next webinar, so watch this space on that, and hopefully you've enjoyed today's content. If you have any specific questions on the content or anything else, you're very welcome to contact Richard, Peter, or myself. And the details are available on our website or the link to this webinar. So without further ado, wish you all a very good afternoon, and it's goodbye from us. Thank you.